So next question. So this is an interesting question. We get this quite a lot, especially with our agents, especially because I think of that, the understanding that people have on what calendar month in the lease agreement, 20 business days notice. Now, that's almost effectively a month, but does it start from the first of the month? So this whole month day thing gets very confusing on how it's calculated. Even lawyers get confused because the rules say days and the acts say days, and no one knows how to calculate it, and Christmas and all of that jazz. So this question is for clarification. If a lease is signed with a pro rata month due to tenant moving in the middle of a month, does the lease start on occupation date or on the first of the month following which will be the full calendar month? I think you get the gist of that question. I read it verbatim, but I think you get the gist.
Yeah, so perfect. So the most important thing when it comes to these particular questions is what you've got put into your lease agreement. Okay, so the one thing I want to caution people about is we often get lease agreements where people have done something creative with regards to where the lease agreement starts or this additional period or whatever the case is. And that creativity often causes more problems than not. Okay. And really, when it comes to these things, lawyers have to grapple with different time periods. And for those viewers who know about the Consumer Protection Act, it's now talking about business days instead of normal days, and this is different. From a legal perspective, your lawyers have to know this distinction between business days and court days and whatever else. But for the most part, most people who are functioning within our economy and doing commercial transactions, unless there's a specific indication that a different type of day needs to be used. So your Section 14 of the Consumer Protection Act requires business days. And it sets that out specifically for you. And if that is not specifically set out, use normal days and understand days as every day of the week within a month. Okay, there's no need to overcomplicate it more than that. All right. And even when you use business days, you're using normal business days. Public holiday is not a day for business. Christmas is not a day for business. We all understand this. Okay. But with regards to time periods, so the first thing to understand is obviously in our legal system, in South African law, and in particular, when it comes to lease agreements, you have a freedom of contract. Okay, for most terms, you have the ability to engage with one another as you want. There are certain limitations that are placed on residential lease agreements, as is required in terms of the Rental Housing Act. So that does place some requirements on you. But for the most part, even with what is required in terms of the Rental Housing Act, you do have freedom of contract and the ability to contract with one another as you wish. Okay. So when it comes to time periods and when leases start and when they terminate, for the most part, okay, you do have the ability to transact with one another as you wish. Okay. So the thing about this question is they've got a commencement date, and it seems that there's some pro rata period, okay, before the intended commencement date. Okay. Really what the question comes down to is, well, what do you have in your agreement? Okay. It is perfectly possible for a lease agreement to start on a particular day, so on the first of a month, and an occupation or possession of the property to be handed over prior to that particular date that it starts. There's absolutely nothing wrong with that. Okay, and that happens in within our law on an ad hoc basis. So people simply, I've recently placed a tenant in one of my properties. I simply gave her the keys a week before. It's absolutely fine. The lease agreement's in place. It only started, a week later, but there's no problem then, and there's a pro rata rental payable. The commencement date is still what is stated within the lease agreement, being that X date. Okay, and you can do it formally as well. So for a lot of our commercial clients, what they do is, if you have a commercial building where there needs to be a fitting out, a tenant's installation, which is done, often what is granted to the tenant is a beneficial occupation period, and that's actually drawn into the contract that says, well, our lease will commence on a particular, on a particular date. So say, the 1st of August, the lease agreement is going to commence in earnest. But for the period of July, you're going to have a beneficial occupation period. And that beneficial occupation period, you're either going to not pay rent, or you're just going to be liable for utilities or whatever else is agreed to within the lease agreement. So you can be really creative with these beneficial occupation periods. You can figure out exactly how you want to deal with them, what are the charges that are going to be available. And there's absolutely nothing wrong with that. You have the ability within our law to contract and do these things. And if you don't do it in such a formalized way, it's absolutely fine as well. Give your tenant has an extra week, occupation in terms of the premises. You don't need to worry about, well, how do we deal with our lease agreement at this point? You can still agree that, okay, well, you're going to have beneficial, a pro rata 1 week in the premises before the lease agreement starts in earnest. How do you deal with that? Do you charge rental for that pro rata week? Yes, no. It's really up to the contracting parties to decide. And there's very little, there's very little that you can do that would fall foul of the law in those circumstances, bar, some very, contra bonos mores terms that might go against public policy. That would, in any event, regardless of when a lease agreement starts or finishes, would be unenforceable. But don't overcomplicate the question. If your lease agreement says we're starting, next month, and they get a prorated period for 2 weeks, it's absolutely fine. They just have a prorated period for 2 weeks. The lease agreement starts in earnest on the date that is actually set out within the lease agreement.
Sure. Just out of interest, Nick, to add to that, because what we often find in practice, and you've probably seen this a million times, is everything makes sense. Lease agreement commences on the 1st of the month. What happens in those situations where, unfortunately, people don't actually contract properly, or at least record everything properly? So it's supposed to start on the 1st of the month. Then the tenant goes, oh, but you know what? I need a place now. And he just moves into the property. How would you suggest the viewers deal in a situation where it's not exactly in the agreement, tenants moved in prior to the date that he was actually supposed to?
Okay, so there's a trick to something like that. So remember, for a tenant to move into a property, there's going to have to be some sort of reciprocity which exists between the parties, because unless your house happens to be just open, okay, and the tenant manages to walk in, which is very unlikely within the South African context, the landlord's going to have to hand over the keys, okay? And remember, in terms of our South African law, agreements, lease agreements as well, don't necessarily have to be in writing for enforceability, okay? So at the point where there is some sort of handover, okay, I'm assuming there's some sort of handover and you don't have a tenant who simply broke into the property. If your tenant breaks into the property before the lease agreement starts, this is a very different question. There are other problems which need to be addressed in that particular circumstance. But if it is a circumstance where there is some form of handover of a key, some access is granted, however that's done, okay? And remember, this can be done through an agent, which is very common within our legal sphere, or the landlord hands over keys or remote, whatever the case is, okay? There is some sort of agreement that is formed at that stage, okay? It might even be that you could say that there's an agreement for a short period prior to the commencement of the lease agreement in earnest. And there's absolutely nothing wrong with that either. So for a period of a week, 2 weeks, whatever the case is, the tenant is again given occupation of the premises. And it can be perfectly valid to say, well, for that 2-week period before the lease agreement actual commencement date, okay, there's a tacit form of agreement that is entered into between the parties. The terms of that tacit agreements are going to be on exactly the same terms as my written agreement that is going to commence on the 1st of the month, okay, and for which there is a prorated rental. There's absolutely nothing wrong with that in law. And if you are sitting in a court of law and something goes wrong and a court has to interpret this period, before the lease agreement commences in earnest. That is how the court and our legal system is going to look at these circumstances. They're going to say, well, there was clearly some form of agreement that was entered into, because the reciprocity of, well, I'm giving you the keys and you're moving into the premises. There has to be an agreement that is legally recognized in those particular circumstances. That's why I say the time that would be different, the circumstances that would be different, is if there was some sort of forced entry into the property, in which case that you can clearly see that reciprocity is not there. And so there's a different type of relationship now, potentially criminal in nature.
Sure. Oh, awesome. Thanks so much, Nick.
Perfect. And I think that brings us to the end of the day. So thank you very much, Bruno.
Awesome.
And,
Thanks.
we'll see you next week.
Cool. Thanks, guys. Cheers.